Well, good afternoon, everybody. And on behalf of Baker McKenzie, thank you very much for joining today's Financial Institutions Focused webinar, where we're going to be looking at some key regulatory developments and enforcement themes in the financial services space during 2023. To do some brief introductions, my name's Mark Simpson. I'm a partner based in the London office where I head up the Financial Services and Regulatory Practice Group. I'm very pleased today to be joined by 5 of the other lawyers in my team. Firstly, Caitlin McKerlane, who's a partner advising on a range of regulatory matters. Philip Annett, another London partner with a focus on FCA and PRA investigations and enforcement, and who previously was working at the FCA in its enforcement division and also at the Serious Fraud Office. I'm also joined by Sarah Williams, Senior Associate in London, who has a particular focus on consumer matters, by Shanil Shah, an Associate focusing on a range of advisory and contentious matters, and one of our leading experts on ESG issues. And last but not least, by Kim Everett, Senior Knowledge Lawyer based in London, but covering EMEA-wide developments, who's very much the brains behind today's session. So if we can move on to the agenda. So by way of general introduction, although there's never a quiet moment in the world that we all inhabit, it feels like 2023 is really poised to be a year where, even by the usual standards of our space, an awful lot of things are going to happen. So we've got a very packed agenda today. At a domestic level, the most important piece of primary legislation really since the 2000 FSMA legislation is currently making its way through Parliament, and that really is promising to create a wholesale and far-reaching changes to our domestic framework. It feels like this will be the first year really where we meaningfully in the UK start to diverge from the EU, moving away from the somewhat black letter approach of EU law and replacing that with a more principles-based and allegedly agile system. We're also going to be seeing a significant modernisation of the FSMA legislation, bearing in mind that it was 23 years old now and reflecting the very different way in which we all experience financial services from how it was back then. We're also seeing advances in technology and the increase in access to financial services online, which has driven mini booms, as we've seen, in areas like crypto and buy now, pay later products, and driven wider changes in the way that consumers pay for goods and services. So we're going to be seeing how these are reflected in various policy initiatives designed to widen the scope of the regulatory perimeter. Although the focus of many of the topics we're going to cover have been around enhancing consumer protection, we're also seeing legislation being brought forward to take account of emerging technologies around things like stablecoin payments and the prospect of payment systems using distributed ledger technology, which could become systemically important in the future. We can observe also similar trends in the EU, which is bringing forward its own rules in some of these areas. We're starting to see also the beginning of some regulatory competition as between the UK and the EU, with each somewhat looking to the other for inspiration, but doing things in a sufficiently different way to keep people like us gainfully employed. We'll be seeing that things are moving at a very fast pace, such that it's really difficult for policymakers to keep up. The recent events in the crypto market are a good example of that, which have caused some to question whether the existing reforms on the table in this space go far enough and address sufficiently the risks we've seen over the last few months. In the midst of these changes, firms will also need to implement one of the most important set of rule changes with the advent of the FCA's consumer duty, and we'll be coming back to this in a bit more detail later on. We're also seeing regulators take early steps to grapple with further technology advances at a more nascent stage of development, notably around things like artificial intelligence and the advent of quantum computing, which has the potential to be very revolutionary in our sector. So we're likely to see the authorities taking further steps to educate themselves about the potential of this technology as well as its risks during 2023. And we're also seeing a continued regulatory focus on enforcement. So the last 12 months have seen some really quite eye-catching fines on areas like AML. And as Mark Stewart's tenure at the FCA draws to an end, there's a sense that more investigations that are run under his tenure may be reaching their outcomes. So we've got 6 key themes we're going to go into more detail on today. After giving a short intro, I'll pass over to Philip, who's going to spend the first part of the session giving us an update on the key regulatory enforcement statistics from last year and how these compared with previous years, as well as drawing out some macro level themes that we saw. Philip will also then predict what we might see coming down the line in 2023. Next, Kim is going to give an overview of the policy agenda here in the UK, focusing on some of the key initiatives coming out of the Edinburgh reforms and the current Financial Services Markets Bill in Parliament. And we'll be looking at both the substance of what is in these packages and some thoughts on next steps and timelines. After Kim's segment, we'll then get into some more detail on some of the more specific initiatives here in the UK, but also in the EU. Where relevant, we'll cover developments for specific subsectors. Caitlin's first going to look at reforms in the markets and investments area, where we'll cover various topics, including the reforms to the UK short selling regime and PRIPS framework, as well as some of the parallel initiatives in the EU, MiFID review and EMIR reform. We'll then hear from Chanel, who's going to spend some time looking at what continues to be one of the hottest topics in our space, ESG regulation, in particular looking at the EU Sustainable Finance Disclosure Regulation and its interaction with the taxonomy regulation. We'll also compare that to the UK's own regime developing around market disclosures and the new anti-greenwashing rule. Next, we're going to cover with Sarah the topic of consumer protection. We'll spend some time looking at the consumer duty, where we'll look both at the key concepts and also give some practical suggestions about what firms should be doing to prepare over the next few months. In this segment, we'll also cover some other key changes in relation to financial promotions in the investment services and crypto space, and then move on to look at some key changes around consumer credit and payments, including the modernisation of the Consumer Credit Act and key consumer protection proposals included in EU and UK reviews of the payments framework. Finally, we're going to spend some time at the end of the session looking at some of the other fintech-related developments. So I'll be looking at the fallout from FTX and the approaches being taken to regulating crypto assets here in the UK and in the EU under the proposed new MiCA framework. We'll also touch on some of the reforms in the payment services and payment systems framework here in the UK. Finally, we'll update on proposals at EU and UK level around bringing unregulated technology companies within the perimeter under the DORA and UK critical third parties regime. So we've got quite a lot to cover. We'll try to leave some time at the end for Q&A. Before we get started in earnest, I'll just make a few housekeeping points. So if you want to submit a question today, please use the Q&A box at the bottom of the screen. We'll do our best to get to these, but if we can't get to it, then we will follow up with you after the webinar. Also, the session is being recorded and will be shared after the event for reference. So if you do need to dial off early, then you can see some of the remainder of the session when we send it to you. So without further ado, I'm going to pass now to Philip for the first of our topics on regulatory enforcement. Over to you, Philip.
Thanks, Mark. Good afternoon, everybody. So as Mark mentioned, I'm going to spend the next sort of 5 to 10 minutes just summarising some of the latest developments from an enforcement perspective. So just turning to the first slide, and this sets out some details of the cases that have been brought, the outcomes of the past 3 years, and categorises them into financial crime, market abuse, and other. The kind of clear and obvious sort of trend that you can see over the past 3 years is very much the theme remains on financial crime cases. And those cases, the numbers of them have increased quite steadily over the past 3 years. If we move on to then the next slide, which shows us some more detail about the amounts of the penalties that are actually imposed in those cases. And again, the theme is very much in financial crime. We see that 6 of the largest fines imposed by the FCA since the start of 2019 have related to financial crime breaches. We then saw another 2 ML-related cases in early January of this year, including a fine on Ghana International Bank for failures in its EDD and its governance processes around its compliance with corresponding banking business. And that's certainly a trend that I think we can expect to see over the coming year, sort of the financial crime and the AML focus. So aside from financial crime, what else has the FCA and the PRA been focusing on over the past 12 months or so? So moving on to the next slide, we can see a number of enforcement themes aside from financial crime. Firstly, looking at the retail banking sector. So operational risk management and governance failures, including management of some outsourcing risks, and perhaps not as many on the retail side as we would have expected to see, but we'll come on to and talk about that in a bit more detail later on. Consumer credit has also been under the enforcement lens, and pensions advice also remains an area of focus. And then market conduct. So we have seen, interestingly, an increase in market conduct outcomes over the past year. Some of those have been a focus on mistakes or omissions in transaction reporting, breaches of MAR, trade surveillance. And we also seen a continuing focus on a failure to manage conflicts of interest. However, one of the more notable absences over the past year, and indeed really over the past sort of 4 to 5 years, has been in relation to insider dealing investigations. So there hasn't really been much of a development in that space over the past year. However, I did notice it was literally 1 minute before the session started that the FCA has just made a public announcement that they have brought criminal proceedings against 5 individuals for insider dealing matters. So clearly they wanted to get that pushed out before a session started. And then lastly, non-financial market misconduct. Even though there's been sort of considerable coverage on that topic in FCA speeches and also in policy documents, we haven't really seen that come to the fore from an enforcement perspective. We submitted a Freedom of Information Act request to the FCA about a month ago, and that reported back that there isn't really very much even in the pipeline in relation to non-financial misconduct type cases from an enforcement perspective. So then moving on to what we think some crystal ball gazing we'll see in 2023. And if we have a look at the next slide, we've just sort of set out a few topics here that we think perhaps may come to the fore more so. Firstly, action against senior managers. So whilst the regime, certainly for the banks, has been in place now for several years, we have not seen really many cases publicly being announced, successful cases that is, against senior managers brought by the FCA. However, it does seem that the FCA isn't sort of too disheartened in that, because they have been commencing year on year more investigations. Again, we put a Freedom of Information Act request to the FCA just at the end of last year, and they reported back that they have now got an excess of 50 open investigations against senior managers. And if we compare that statistic to sort of about 18 months ago, it's pretty much more than doubled. So clearly a continuing area of focus, but again, not really many tangible outcomes to speak of. We're also going to be, there'll be the upcoming review of SMCR, and that'll be interesting to see what that means for current investigations and investigations going forward. And Kim is going to touch on that a little bit more shortly. We also may see, just looking forward to sort of other areas and points that the FCA may be focusing on this year. Perhaps they may try to close the Frensham gap. So for those of you that are unfamiliar with the Frensham case, just by way of very brief background, Mr. Frensham was banned by the FCA a few years ago after he received a criminal conviction. The FCA in turn, as they've done a number of other cases, they considered that he lacked integrity on the basis of that. Frensham challenged the FCA's decision to the upper tribunal, and this was of particular interest because it was the first non-financial misconduct case to be considered by the upper tribunal, not involving dishonesty, and where the behaviour concerned was unrelated to regulated activity. Interestingly, the tribunal's decision was that a conviction for a criminal offence does not in and of itself automatically mean that the person should be deemed to be not fit and proper. And there were various other aspects should be taken into account, including the relevance of the offence to the person's role. Overall, the tribunal did find in favour of the FCA, but not on that ground, but more so on Frensham's conduct after he had been arrested, and the fact that he hadn't sort of made disclosures to the FCA. So kind of looking forward to that case and the ramifications of it, that outcome, perhaps that's one area that the FCA may look over the course of the next sort of 12 to 18 months to really try to strengthen its policy and regulatory guidance, especially in relation to its objectives in order to make some of those ties more clear. Also looking at then retail sector enforcement, as I mentioned, there hasn't been sort of a huge amount in that area over the past 12 months, but that's certainly an area looking forward. I think we can expect to see a lot more focus and emphasis, particularly with the impact of inflation, the cost of living crisis, and the FCA's increasing focus on vulnerable customers, and a number of the sort of correspondence and the DRCO letters that we've been seeing, which have been sent to insurers, banks, and other firms. Then very briefly, mentioning greenwashing enforcement. We're going to touch on this very briefly again later in the session. That's one area that the FCA has sort of previously announced that they've got a number of cases and their enthusiasm for bringing them, but equally sort of post around the time of COP26, the FCA stated, and I quote, that they were in no rush to wield their big enforcement stick in this space, but perhaps we'll see later this year more inclination from their perspective to start commencing some cases in that area. And then very lastly, and to finish up on the end of the Mark Stewart era. So he will be departing as head of enforcement in a couple of months' time. I think his successor is yet to be announced. His tenure has particularly sort of been seen by very much a high level of investigations, and investigations taking an increasing long time to near their completion. So it'll be interesting to see how his successor sort of manages that dynamic. Certainly a priority I think will certainly be getting a handle on the increasing length of the investigations, which have jumped up from about 18 months a few years ago to sort of nearing 3 years. That may mean culling some of the pre-existing cases to try to have leaner investigations and quicker outcomes. And perhaps that may also be dependent on whether it's an internal or an external appointment, perhaps with an internal appointment being maybe slightly less likely to sort of make sort of major changes to the existing enforcement approach. So that was everything I was going to say. I think I've taken up my 10 minutes on the enforcement piece. So I'm very happy to answer questions at the end, as Mark mentioned, and I will now hand over to Kim, who is going to touch on UK policy direction during the course of this year.
Great, thanks, Philip, and hi everyone. So if we carry on over to the next slide, where are we now? Well, it's been 2 years since the end of the Brexit transition period, and the dust has started to settle, I think, on the post-COVID-19 pandemic into a sort of normality. Now that had started to settle only for it to be kicked up again with great force by the conflict in Ukraine and the current cost of living crisis. So taking stock of the regulatory landscape, significant work has been and will continue to be done to reshape and strengthen the UK financial services regulatory framework in light of these developments. So in the post-Brexit context, the broader theme here is shifted to UK-EU divergence and the development of a post-transition UK law from retained EU frameworks. Now, throughout 2022, the Treasury consulted on the future regulatory framework review, which culminated in a policy statement on building a smarter financial services framework for the UK, which was issued in December just past. Now, if we go back further, last summer also saw the introduction of the Financial Services and Markets Bill, which I will call the bill, which was, as Mark said, the largest piece of financial services legislation since FSMA, the Financial Services and Markets Act 2000. Now, once finalized, the bill is going to result in a sea change for financial services regulation in the UK. So it overhauls the entirety of the architecture, establishes a framework for the revocation of retained EU law, reforms the wholesale markets framework, implements a regime to regulate critical third-party service providers, brings certain activities involving stablecoins into the UK perimeter, and so on. And I'll talk about the bill shortly, and my colleagues later on will cover some of the more substantive proposals in the bill. So building on this reform agenda that was set out in the bill over the summer, in December just past, Jeremy Hunt announced a package of wide-ranging reviews and reforms, which have been dubbed the Edinburgh reforms. Now, I think that's because they were announced in Edinburgh rather than them having anything to do particularly with Scotland, but we'll go with it. So these reforms have the aim of driving growth and competitiveness in the financial services sector. I'll talk about these in a bit more detail shortly. So if we could go back to the first slide, I'm sorry. Specific programs of reform are also underway at the regulators. One particular area of focus for the FCA's financial promotions regime, which Sarah will talk about a bit later. Another is the appointed representatives regime. So here the FCA has sought to assert greater control over AR arrangements by way of changes to the AR regime that have recently come into effect. So among other new requirements to bolster the oversight regime is a requirement for pre-notification of at least 30 days before an appointment takes effect. And I think we can expect heightened scrutiny from the FCA on firms that have or intend to have these kinds of arrangements in place. Now, finally, in the face of the cost of living crisis, regulators continue their work to enhance regulations from lessons learned from the pandemic in relation to vulnerability and consumer protection. And Sarah will talk about these a bit later as well. So if we move to the next slide, I'd like to talk a little bit about the Edinburgh reforms. Now, one might wonder why, since Brexit, so little of the UK financial services framework has been remolded to fit the UK markets, although that is, I would say, likely to be unsurprising, given how strong a role the UK played in shaping EU frameworks, and indeed, how often it succeeded in advocating for the adoption of the version of the regulatory frameworks that the UK itself saw as preferential. Of course, while it was a member of the EU. And early on, when discussions on equivalence were still being given lip service by both the UK and the EU, it's easy to see, I think, why the UK didn't overhaul its regulations from day one. So enter the Edinburgh reforms. These proposals have the potential to be hugely wide-ranging. And as I said before, they involve significant changes to the banking, capital markets, payments, regulatory frameworks. They touch on consumer and wholesale business. They deal with ring fencing. They deal with the senior management certification regime, reforms to PRIPS, changes to short selling, reform of the Consumer Credit Act, and so on. They've been billed as a further radical reopening of the UK financial markets following Brexit. So it's also clear from this package that aside from Brexit, the UK is now prepared to begin considering some of the major defining features of UK domestic regulation, like the ring fencing regime and the senior management certification regime, both of which have been globally influential. And we can see a loss of jurisdictions, in particular with regard to individual accountability, taking inspiration from the SMCR, both of which are certainly entrenched in the UK. So this seems quite revolutionary, right? But when you dig into the detail, a lot of these reforms are really the announcement of future reviews and consultations. And I think those could end up being more evolutionary than revolutionary. Certainly than would have been expected given the magnitude of the launch around the Edinburgh Reforms package. So they've also been spun as an advantage of the new Brexit freedoms and an opportunity to make a second big bang to financial services. Now, looking at them, there are about 30 different work streams. And as the Treasury has acknowledged, only about 18 of those, about 18 of those have nothing to do with what we could achieve now that we're outside of the EU. And about 12 of them are linked to changes that we can now make. So it remains to be seen how much will end up diverging from the EU. And remember, feelings for divergence are also mixed in the industry, with firms that operate cross-border, like large multinationals, or firms with businesses that naturally operate cross-border, like payments firms, being more concerned about how significant divergence from the EU will affect their ability to do business in multiple jurisdictions. And when we look at timing, the Treasury has grouped the reforms into 3 tranches. Work has already begun on the first, so that includes securitizations, Solvency II changes, and changes arising from the wholesale markets review, which Caitlin will talk about shortly. The government expects to make a significant progress on tranches 1 and 2 by the end of 2023, which may be aspirational, but that's what they intend to do. Now, the pace of the changes will vary. Some, like the replacement of PRIPS with a new retail disclosure regime, are already underway and should be completed early on, I think mostly because that one doesn't require new legislation to be passed. My colleagues will talk about that one a little bit later as well. And others like short selling, the senior managers regime are further behind. The short selling review call for evidence is open until March, after which there'll be a further consultation. And the SMCR review doesn't even start until sometime in Q1 this year. So that's even further behind. Now, the other thing to remember is that we can expect anything that's not finalized or in progress by the end of 23 to be effectively paused when 2024 starts, given that we expect the election to take place that spring, unless, of course, that's brought forward. Now, with the Edinburgh Reforms Programme, it's important to remember that it's a policy programme, but all policy programmes are born out of politics. And given that Labour is at this point expected to win the election, it's unclear what their political ideology will do with the politics of the Edinburgh Reform policy. Given that we've seen that they have some hostility to what they see as the race to the bottom in these reforms, and the public reaction, rightly or wrongly, to the announcement of the removal of the bonus cap. So we'll have to see where that goes. If we move to the next slide, I just wanted to illustrate here the scale of the program that the Edinburgh Reforms set out. I'm not going to talk about this in any detail, but as you can see, it spans a multitude of sectors across nearly the whole of the financial services industry. And subject to all the caveats and nuance that I just talked about, it really has the potential to be the game changer. So let's move to the next slide and talk a tiny bit about senior managers and certification regime before, because while we still don't have concrete details on what the Treasury might look at, there are some clues here and there about what we might look out for. The Treasury says that it's going to ask about effectiveness, scope, and proportionality, and seek views on potential improvements and reforms. So it's interesting that the Treasury is hinting at reforming this regime so soon after its implementation. It was just introduced in 2016, that's less than 10 years ago, and it only fully applied to all authorized firms, all FSMA authorized firms, I should say, in 2019, which was just 4 years ago. And regulators have been positive about its impact. So a PRA evaluation from December 2020 found that the introduction of the regime helped ensure that senior individuals in dual regulated firms took greater responsibility for their actions. And that a large majority, so 95% of dual regulated firms surveyed agreed that the regime was having a positive effect on individual behavior. However, as Philip alluded to, the low volume of SMCR enforcement action has been open to criticism. And some have argued that rather than working as intended, the lack of significant SMCR enforcement action means the regime hasn't had the impact intended, especially in light of the significant compliance costs that it has imposed. So looking at how the regime might change, I thought that this quote from Andrew Griffith's evidence to the Treasury Select Committee on the 10th of January was quite illustrative, and I'll read it out. Then there is the substance or content of the various requirements. The key point is that this is a regime about financial risk. That is the moral hazard here that we are trying to eliminate. It's not really to go into broader areas of how a firm conducts its business, but diversity and inclusion or environmental agendas are really important. They're important to this government and they are important to me, but you have to keep a regime fairly narrowly within its tram lines for it to be fit for purpose and not let it range into other areas of how people run their firm. If Parliament wants to do that, it is for us to do that, not for scope creep under something like a senior manager's regime. Interesting, right? So if I had to predict, I'd say that the SMCR will likely stay in its current form, but that the Treasury might try to narrow the parameters of what can be regulated within the perimeter of the SMCR. But the evidence is interesting, not least because it seems that the FCA would really like to tie D&I somehow to the SMCR. And in that, it looks destined for a fight with the Treasury. And one final point on this, one potential knock-on effect to look out for in the SMCR. So the past few years, the pandemic remote working environment, the supply chain squeeze arising from the Ukraine conflict, and the cost of living crisis, and then thinking about the forthcoming consumer duty regime. These all have put conduct risk in the spotlight, and we've seen the FCA come out strongly in the past year on maintaining good conduct and culture, with heightened enforcement risk for firms who don't clear the bar. So the SMCR review has the potential to weaken these conduct arrangements further if it ends up watering down the regime or making enforcement action more difficult than it already is. So together with the review of the retail disclosure regulations, which we'll talk about a bit later, these reforms might put additional pressure on conduct risk frameworks to pick up that slack. So let's move on to the next slide. Finally, we'll take a quick look at the bill and what we might expect. Now, Andrew Griffith intends for the bill to go through all of its stages by spring 2023. We'll see if that happens, of course, but the Treasury will need to pass commencement regulations in order for specific provisions in the bill to start to take effect. I've already talked about a lot of what the bill does, though I won't talk about those measures. I'll also mention that it introduces a regulatory gateway that authorized firms need to pass through before they begin to approve financial promotions. Now, Sarah, I think we'll talk about that a little bit later. And it sets up an access to cash regime, which is quite interesting. And there are many, many more things. I'll just talk about three key provisions that I think are good from a policy perspective to discuss. One is the repeal and replacement of EU law and shifting to a FSMA model of regulation where requirements are in the regulators' rule books. So this will shift as many of the retained EU law frameworks into the remit of the PRA and the FCA under the FSMA model. rather than those requirements being in legislation. And this facilitates much of the work that's going to be done by the Edinburgh Reforms Programme, reviewing retained EU law with a view to repealing and replacing. Now, going forward, firms with existing or prospective operational footprints in Europe are going to be faced with a whole host of new regulatory and commercial challenges, with the potential for all of this increasing divergence from the EU as we see these programs undertaken. But I would note that the program of replacing retained EU law is going to be a massive undertaking, and it's going to happen in phases. So despite the government's intentions, there's no statutory deadline to get it all done by the end of 2023. And as we've seen, there's no chance that some of these programs will be, some of these files, I should say, in the Edinburgh Reforms package will manage to be completed by the end of 23, of course. The next thing I'd point out is the designated activities regime, the DAR or DAR. So there are some areas of retained EU law that apply to unregulated as well as regulated activities, like the short selling regime, regulation with it. To avoid bringing these into the scope of the regulated activities regime and the authorization requirements that will apply, the bill allows the Treasury to set up the DAR. Now, this allows activities relating to financial markets to be regulated in a framework which is under the FSMA model, but without the authorizations regime that applies to regulated activities. The Treasury will be empowered to make regulations specifying designated activities, like, for example, entering into derivatives contracts or offering securities to the public. The regulations will stipulate whether that activity is prohibited or permitted, subject to compliance with certain rules. And the Treasury and the FCA can both make rules which apply to the activity. Rules made under the DAR are limited to the designated activity and don't apply to the other activities of the firm. It's important to remember also. And finally, I'd point out the new secondary international competitiveness and growth objective for the regulators. And we've heard a lot about this recently. So this is to facilitate, subject to aligning with relevant international standards, the international competitiveness of the economy in the UK. Now, in the explanatory notes to the bill, the government states that it doesn't want PRA and the FCA to act in a way which benefits short-term competitiveness at the expense of long-term growth. So that's something to remember. Now, two things that didn't make it into the bill, which I thought were interesting to mention. The government backed down over inserting a call-in power into the bill, which would have allowed for the Treasury to direct the regulators to change their rules in some circumstances. Now, the regulators pushed back on this in the beginning and said that this would undermine our independence, and the government conceded to that point. The government also decided against including provisions in the bill relating to refusals by payment services providers to provide services for reasons that are connected to freedom of expression. Now, this issue, as you'll hear later in the session, has been included in the Treasury's recent payment services regulation review. So they are addressing it, but they're not going to do it in the bill. Has been a canter through what's going on from a policy perspective. I'll now hand over to Caitlin to talk about markets reform.
Thank you, Kim. Great. So I guess on markets reform, the pace of markets regulatory reform in the UK is fairly fast, and it encompasses some really fundamental components of our regulatory framework. If you were to just sort of glance at the list of reforms that HMT and the UK government is looking at, you would be forgiven for thinking that almost everything is on the table. But as Kim has said, that is particularly the case, given that there's been some reluctance, shall we say, on the European Union's part around granting equivalence under MiFID II and other regulations. So if equivalence wasn't an option at the time when the UK effectively had an identical set of financial services regulations, there seems to be little incentive to hold back on making some wide-ranging reforms if the government chooses to do so. However, against the backdrop of how much markets regulation actually originated on the desks of UK regulators while we were still a European Union member state, on the other hand, it does seem likely that our policymakers have an interest in maintaining at least a degree of the status quo. And I think one theme that I'd like to draw out during this section is really divergence. Markets regulation has really been a key sort of Brexit battleground, if you like, between EU and UK regulators. So on MiFID II reform, we've already seen some divergence around the levels at which UK and EU regulators are willing to accept dark pool trading and the treatment of systematic internalizers. While the EU is continuing to use the MiFID framework to encourage trading volumes onto primary listing venues, the UK is arguably taking a broader view of the benefits of alternative venues and exchanges. So overall, we're seeing a more liberal attitude from UK regulators to the use of systematic internalisers. For instance, the SI definition in the UK will just become qualitative in nature, which should remove some of the rather onerous calculations that currently apply to investment banks. There's a fair amount of history actually that underlies this divergence in approach. So systematic internalizers, for the uninitiated, are large banks and broker-dealers that execute a high volume of over-the-counter proprietary trades. EU policymakers have a degree of cultural preference towards larger lit exchanges over trades that are entered into direct with dealer banks. And it was only really when MiFID I was implemented that EU member states were required to actually entirely abolish what was called the concentration rule, where investment firms were required to route their orders to national stock exchanges. So in other words, Europe's or continental Europe's trading infrastructure has grown up more around transparent bourses and order book systems and less around quote-based trading. Connected to this has always been a very strong push for trading to occur in a lit, transparent environment in the European Union, which is a bit more tempered in the UK, with UK regulators being somewhat more favourable to the advantages that dark pool trading can have, at least for certain order types. So looking at the MiFID II reforms that are going on, we can see that the UK is intending to entirely dispense with what's called the double volume cap, which is effectively a mechanism to shift trading onto a lit environment when dark pool trading reaches a certain threshold, whether at trading venue level or EU-wide, hence the term double cap. Although the same proposal has been raised at EU level, there is markedly more resistance to it. For instance, the Council is now proposing that the same mechanism remains in place, but subject to a single cap. So it's a commonly held view that buy-side firms tend to like choice and competition when it comes to execution venues, and many in the market can also favour dark pool trading depending on their trading strategy, how they work orders and so on, which raises a question as to whether, as a result of these reforms, EU firms could be encouraged to trade through UK exchanges and market infrastructure rather than onshore in the European Union. In other words, will the UK's approach to choice and competition between execution venues as a result of these MiFID reforms prove more popular in the market than the EU's slightly more restrictive approach? That is a possibility, but perhaps unfortunately for our markets, this kind of tinkering is very unlikely to make a significant dent in the huge shift in equity trading volumes that we saw in the wake of Brexit, thanks to the MiFID share trading obligation. In the 3 months after Brexit, London-based venues saw their share of the consolidated market in equity trading fall to around 22% from almost 50% prior to the split, which is really quite startling, and it gives you some indication of how regulation can be used to keep trading onshore, which is another theme I'm going to pick up on. We now know that, unlike the European Union, which used the share trading obligation to encourage this onshoring of trading activity, the UK is going to ditch its share trading obligation entirely, which gives quite a clear indication that we're unlikely to get political compromise on equivalence anytime soon. There's also a very specific issue I'm going to mention that has arisen in relation to MiFID, since it's had a bit of press in the US. You may recall, if you dialed in from an investment firm today, that MiFID II implemented a rule requiring research and execution costs to be unbundled and paid for separately, including by portfolio management firms. And in the US, the provision of research and broking services are dealt with under two quite separate regulatory frameworks. And there's always been a concern in the US that if brokers were to offer research that's priced separately from execution services, they would need to become registered investment advisors, which would be a nightmare for them, frankly. As a result, the SEC initially brought in no action relief, allowing US brokers to provide research on an unbundled basis without triggering these additional US regulatory requirements. We're now on notice that that no action relief is going to expire in July this year. So unless the FCA relaxes its requirements, and it has stated that it's monitoring the situation, UK portfolio managers will need to ensure that their US brokers are either able to continue unbundling the costs of research, for instance, because they have an affiliate with the necessary licenses, or at worst, they may need to terminate their relationship with that broker or use them for execution-only business. So stepping away from MiFID, EMIR, which is our framework regulation on derivatives, is in contrast not a reform priority in the UK. It's not included in any of the Edinburgh reforms, tranche 1 or tranche 2 files. So we know that we're not going to see any significant reforms on EMIR come out before the end of 2023. That's really no great surprise because EMIR is largely bedded down in the market, and the reforms have achieved in large part what they set out to do, pushing standardized contracts through clearing, reducing buildup of systemic risk, and so on. ISDA has recommended that the UK government think about reviewing intra-group exemptions to EMIR, but that's a relatively technical point in the grand scheme of things. At EU level, on the other hand, we are seeing far more wide-ranging reforms on EMIR clearing rules that are focused on the CCPs that counterparties use to clear contracts. That is, again, reflective of the focus that we've already spoken about on encouraging EU firms to use EU infrastructure. And certain EU policymakers have for quite some time, and certainly pre-Brexit, been very concerned about euro-denominated trades being routed through non-EU infrastructure. And there's some basis for those concerns. The EU is an absolute outlier when you look at the level of local currency-denominated trades that are routed through infrastructure sitting outside of the Eurozone. Brexit really accelerated these concerns on the part of EU regulators, given clearing volumes that go through UK CCPs. So bear in mind that as far as EU regulators are concerned, a massive amount of systemic risk in the derivative markets now sits with CCPs, thanks to the EMIR clearing obligation. There have been some moves to have UK clearinghouses, such as LCH, onshore in the EU for some time, which aren't going away. We've had confirmation from the Commission on that. But most recently, we've seen the European Commission publish its EMIR 3 proposals, which would, if they were to be adopted, be far more draconian in nature. And what has been proposed is that counterparties to derivative trades that are subject to the EU clearing obligation will actually need to hold active accounts, either directly or indirectly, with EU CCPs, and to clear at least a portion of their derivatives with them. It's a rather confusing provision, and there's no certainty that it will be adopted. I suspect, however, that it will be given quite serious consideration at the very least by EU politicians, despite the fact that it would be a massive headache for the industry, as anyone who has spent time negotiating a client clearing agreement will know. So on the last two pieces of regulation we were going to talk about, one piece of reform that the UK does seem to be moving along faster than the European Union, perhaps surprisingly, is the short selling regulation. We've had a very broad-ranging consultation out on it, which gets into some quite fundamental aspects of the way that the regime functions, even around disclosure thresholds. And those of you who are in organisations that take short positions in shares will recall that the UK chose to reduce its reporting requirement to regulators from 0.2% to 0.1% in net short position during the trading volatility that we saw through the pandemic. And we since made that 0.1% threshold permanent, both in the UK and in the EU. The FCA clearly quite likes having that data, so it would be a little bit surprising if the UK government then increased that threshold again to 0.2%, but it does appear to be giving consideration to that. Final sort of notable mention, to the surprise of no one, the UK is intending to repeal the PRIPS regulation entirely and replace it with a new retail disclosure regime. The EU PRIPS regulation, drafted with very good intentions, was effectively intended to bring into effect a short standardized information document about the risk versus return profile of a range of financial products, but unfortunately attempting to apply the same set of formulae across a host of very different financial instruments in the market. didn't work particularly well, and there was a notable incident of the FCA effectively publishing advice to the market that certain key information documents could even be misleading in nature. So PRIPS is going to be taken off the statute books and replaced with a more flexible set of disclosure standards with prescriptive requirements for format and structure only being put in place by the FCA where it's considered necessary. In some respects, that leaves a bit more risk with product distributors, given that they may be left making a determination around what best fits the needs of retail end investors. But in general, I certainly view it as a very positive development. And I think what was interesting about the process of implementing PRIPS was that it forced a lot of non-EU firms such as asset managers and banks not only to unpick whether there was any prospect of their products ultimately being marketed to EU retail clients, but also drafting quite restrictive clauses around potential sales to retail end investors as a result. And I think when you're a lawyer in private practice, you don't always think about the macro implications of that. But when the UK government stood back and looked at it, that had a very clear impact on retail choice of investment products. So that kind of demonstrates the power that disclosure standards can have in the market and why they're such an area of focus for the FCA, which I think Mark may come on to a little. So we reached the end of this section, and I'll hand over to Shanil on ESG reforms, I think, which has been keeping us very busy over the last year.
Thanks, Caitlin. If we go over to the first slide, please. Over the past year, we've seen a proliferation in ESG rulemaking. And unlike in previous years, this hasn't been geographically restricted to the UK and the EU. Instead, we're now seeing the globalization of ESG, and with countries in particular in the APAC region and of course the United States, developing and implementing their own sustainability disclosure regimes. Firms operating in the financial sector are finding themselves subject to increasingly wide disclosure and reporting obligations. And those operating cross-border are having to navigate multiple applicable regimes with all the additional complexity that entails. So just a brief recap on where we are with the EU's ESG regime. On the back of various initial international initiatives, such as the Paris Agreement, the European Commission developed the Action Plan on Sustainable Finance, and that has ultimately resulted in two core regulations applicable to the financial services sector, the Sustainable Finance Disclosure Regulation and the Taxonomy Regulation. The ultimate goal of the SFDR is to make it easier for investors to compare the sustainability criteria of the various products and also to prevent greenwashing. And the way that it achieves this is through implementing a disclosure regime. The SFDR applies to so-called financial market participants, which is a wide range of participants in the financial markets, including AFIMs, UCITS, ManCos, insurance companies, pension product providers, banks, investment firms, and also financial advisors in respect of in-scope financial products. And it's important to keep in mind that the regime isn't just applicable to EU-based persons or products. It also includes, for example, funds that are marketed into the EU via national private placement regimes. The EU's taxonomy regulation, as mentioned, is the second pillar of this regime, and it establishes a classification system which provides firms with a common language to identify whether or not a given economic activity should be considered environmentally sustainable. If we move on to the next slide, we'll see that a product classification under the SFDR ultimately impacts the level of disclosure it's required to make, in particular under the taxonomy regulation. We essentially have three different types of products. Article 6 are effectively the baseline. This category captures all products that don't have any environmental, social, or sustainability ambitions, whereas Article 8 products are those that promote environmental or social characteristics, and Article 9 products are those that have sustainable investment as their objective. Another important legislative initiative that interrelates to the SFDR is, of course, the Corporate Sustainability Reporting Directive, the CSRD. And this replaces the current non-financial reporting directive regime and requires all large EU companies and also certain non-EU companies to start to disclose more information on the way that they operate and manage their social and environmental challenges. So looking ahead, what can we expect from the EU's ESG regime in 2021? Our first prediction is that we expect the pace of regulatory change will continue over the next year. This is really the first year that ESG reporting will become embedded within firms' day-to-day operations. Market participants within scope will need to issue website, periodic, pre-contractual disclosures as well, setting out the alignment of their products against taxonomy and the SFDR. If we move on to the next slide, we'll see an example template. And from the 1st of January this year, many of these disclosures will need to be made on this template. And not only is this going to relate to pre-contractual disclosures, but it will also relate to certain PAI disclosures as well, all of which are set out in the underlying regulatory technical standards. Until now, it's been very difficult for certain market participants to accurately judge the appropriate sustainability categorization of this product. And we see this year as really the first opportunity that participants have to have broad visibility over the SFDR categorizations being used by their peers. And it follows that we expect these disclosures, which will be made in a more public manner, to trigger further adjustments as the market comes to a view on certain questions around product categorization, for example. So if we look ahead to later this year, we know that the European Commission plans to consult on the implementation of the SFDR and also plans to publish a further set of Q&As on the SFDR. One area that we hope to see some additional clarity on is around the fundamental question of product categorization. On the next slide, we'll note just some thoughts that the Director of ESMA has had in relation to product categorization. And in summary, the notes that we've had from both the Commission and the European Securities and Markets Authority are things essentially that we've known for a while, which is that the SFDR doesn't intend to create a product labeling or a classification regime. And instead, the message is that Articles 8 and 9 in particular are part of a disclosure regime that is simply triggered where in-scope products satisfy the underlying technical requirements. That said, it remains to be seen whether EU legislators consider it necessary to introduce a minimum quantitative criteria for these types of products, and that would of course necessitate amending the Level 1 text, which will take some time. Outside of the SFDR, we also expect the Commission to adopt further granular legislation on certain aspects of the taxonomy, such as biodiversity and the prevention of pollution, and we also expect to see a renewed focus on the implementation of a social taxonomy. On to the next slide, the UK is also moving forward with its own ESG regime and is in the process of implementing its own disclosure and taxonomy regimes. The UK currently has in place a particular disclosure regime for asset managers, life insurers, pension providers, and certain other entities, for example, listed entities, and that is based on the Task Force for Climate-Related Financial Disclosures framework. Alongside this, the FCA is currently consulting on a more granular sustainability disclosure regime that is slightly more analogous to the EU's SFDR and the taxonomy regulation. This will effectively involve market participants having to make a disclosure against the new UK taxonomy. In substance, the UK's SDR regime will involve sustainable investment product labels, which help consumers assess the sustainability of various products. There'll also be additional product disclosures that are specific to consumers, as well as additional detailed disclosures for institutional investors or consumers who are seeking further information. There'll also be rules on naming and marketing, and the FCA will look to restrict the use of sustainability terms such as ESG, green and sustainable in product names and marketing materials for products that don't fall within the SDR. We'll have additional rules for product distributors, and we'll also have a new anti-greenwashing rule that will apply to all regulated firms, the aim of which is to ensure that sustainability-related claims must be clear, fair and not misleading. We'll also see the government publish an updated green finance strategy early this year, which will include hopefully some updates in relation to the UK green taxonomy, progress on which has stalled somewhat. That said, the government has helpfully confirmed that it is conscious other jurisdictions are developing taxonomy regimes, and hopefully that means that we will be able to take a slightly more commercial approach and be able to cross-refer to those other disclosures where necessary. As mentioned earlier, the SDR and the UK's green taxonomy are being implemented alongside the FCA's regime for climate-related financial disclosures, and large asset managers and asset owners are going to need to make their first set of disclosures under that regime on by the 30th of June 2023 this year, and other asset managers and essentially smaller asset managers and smaller asset owners will need to make disclosures as of 30th of June next year. Moving on to the next slide, we see that data has been a significant issue for firms going over the past year or so. A disclosure regime is really only impactful when it takes into account underlying data that's accurate and reliable. Ultimately, the relatively speedy implementation of the SFDR has meant that many market participants have struggled to obtain that data. One reason for which is simply that until recently, corporates hadn't been required to provide the particular granularity required. And that means that it's been difficult for market participants to make their SFDR and taxonomy disclosures. Last year, the message from the EU is very much that market participants have a responsibility to source their own data in a proactive manner, and that failure to do so would ultimately result in a 0% alignment against the taxonomy. Where market participants simply can't obtain reliable and timely data, the guidance seems to be that they can, only in exceptional circumstances, make complementary assessments and estimates on the basis of other data sources. That said, they shouldn't use narrative explanations to simply explain away the lack of taxonomy alignment. The future is looking somewhat brighter though. So we now have the Corporate Sustainability Reporting Directive I mentioned earlier coming into effect, and that means that corporates will be required to collect and disclose far greater and far more granular quantities of data than previously. And ultimately, the aim is that this will filter into taxonomy and SFDR disclosures, and that will enhance the data availability and accuracy of those particular disclosures. Both the UK and the EU are also looking at whether ESG data and ratings providers should be brought within scope of the regulation. The driver behind this is essentially concerns around the transparency of data providers, how they're formulating their methodologies and managing their conflicts of interest. And the message for attendees on this is really to be on the lookout for firms that do ultimately obtain authorization to carry out that particular activity, and also any associated requirements on those firms. So in particular, any requirements to use particular labels or disclosures under the UK's regime where data providers that are regulated have been used. Lastly, if we move on to the last slide, we've just got a brief note on enforcement. We've seen a marked increase in regulatory enforcement over the past year on a global scale, and this is really expected to continue into 2023 as regulators become more involved in this area. For example, the European Securities and Markets, the European Supervisory Authorities rather, are currently looking into greenwashing and particularly high-risk practices, and we expect an initial report around the end of May. Some jurisdictions and regulators have been more forward on this, and others, as Philip mentioned, such as the FCA, have taken a slightly more reserved approach. And whilst the focus to date has been on greenwashing, we've also seen concerns to the market around green bleaching. And this is effectively a practice where market participants invest into sustainable activities or underlyings, and that they refrain from characterizing their products correctly so as to avoid the additional and enhanced disclosure requirements. Given that the rules are primarily designed to tackle greenwashing, it remains to be seen how they will address this particular challenge. And then very lastly, on the litigation front, we also expect to see quite a significant uptick in litigation relating to sustainability regulations, particularly as shareholders are becoming increasingly engaged in companies' ESG claims. So lots to keep in mind on the ESG front. And with that, I'll hand over to Sarah, who will talk us through some developments in the consumer protection space.
Thanks, Neil. So we move to the next slide. Securing an appropriate degree of protection for consumers is one of the FCA's statutory objectives. And we're going to see developments in this space continue, pretty quickly in 2023. Implementation of the consumer duty is, of course, the headline item for 2023. And, it's going to be top of firms and the FCA's agenda as those rules come into force. But there are a variety of other developments that, people should have in mind and should also be in focus. Areas of those focus include, as we've sort of heard, revamping the UK's financial promotions and disclosure regimes, as well as developments in the payments and consumer credit space. However, consumer duty is obviously top of the list. And if we move to the next slide, we'll jump into, what that really entails. I think consumer fairness has been a long-standing focus of the FCA, and there's already rules and guidance across the different sectors which support the fair treatment of customers. However, the FCA has described this as a paradigm shift, and it is intended to trigger significant change for how firms treat their consumer or retail customer base. There's three elements to the consumer duty. a consumer principle which reflects the overall standards of behaviour that the FCA wants to see from firms, cross-cutting rules which then develop that overarching expectation, and then 4 outcomes which give a more detailed explanation of what the FCA see as key elements of a firm and consumer relationship. The overarching principle here is that firms must act to deliver good outcomes for retail customers. So what does that mean? Well, firms need to be asking themselves questions such as, am I treating my customers as I would expect to be treated? It's really intended to make sure that firms move from looking at their internal controls and systems and how those comply with the strict FCA rules to looking at the way in which their internal controls and policies work externally for their consumer customers. Looking at the cross-cutting rules that support that overarching outcome, the first is that firms must act in good faith towards retail customers. Guidance from the FCA provides that this is characterised by honesty, fair and open dealing, and consistency with reasonable expectations that your customers might have. The second is the obligation to avoid causing foreseeable harm. As with the duty overall, this is underpinned by the concept of reasonableness, and you'll hear that word a lot. So firms are only responsible for addressing, the risk of harm that is reasonably foreseeable, considering what a firm knows or could reasonably be expected to know. So you don't need to know everything about your customers and avoid any possible harm, but making sure that you're taking into account what you reasonably could have foreseen. The third and final cross-cutting rule is then the requirement on firms to enable and support retail customers to pursue their financial objectives. Next, we have the 4 outcomes. As I said, these are the key elements, at least in the FCA's mind, of the relationship between firms and their customers. These are, communications, so making sure communications equip customers to make effective, timely, and properly informed decisions about financial products and services. Products and services, so designing your products and services to meet the needs of consumers and making sure those are actually sold to those whose needs you've assessed as being in the target market. Consumer support, so putting in place customer service support that meets consumer need and enables consumers to realize the benefits of the products and services that they buy, and letting customers act in their own interests without any undue hindrance. And then finally, the final 4 outcomes is price and value, so making sure that the price of products and services represents fair value for consumers. These 4 outcomes, do have some specific rules involved, but then they're also underpinned by a lot of FCA guidance. I think that the consumer duty ran to 200 pages of FCA rules, and so handbook rules, handbook guidance, and sort of separate guidance. So it's not a prescriptive regime, and a lot of it is based on doing what's best for your customers. And then those consumer principles and cross-cutting rules and outcomes are then supported through some SMCR changes and governance and board requirements. So, for example, appointing a board champion. There's new conduct rules that require conduct staff and senior managers to achieve the same outcomes as the firm, and requirements around, annual attestation by the board. In terms of timeline, firms have until the 30th of April for manufacturers to complete their sort of consumer duty review, so that they can pass on that information to distributors to make sure they can in turn comply. And then the rules will apply to open products and services from the 31st of July, with a delayed implementation to the 31st July 2024 for any closed products. Despite the implementation deadline still being 6 months away, it is important to note the FCA does expect firms to be stepping up already to support good outcomes. They've stated in speeches and Dear CEO letters, for example, in the insurance industry, that given the current challenges in the UK economy, firms should already be thinking about what they can do to support customers. If we move then on to the next slide, what can firms be doing on implementation? And consumer duty implementation could fill a session on its own. So we're really just going to touch on a couple of high-level points today, but thought it might be helpful to give a bit of an indication of what firms might do. You should, of course, already have some implementation plans in place, and time is now quite tight. The FCA released some feedback this morning on its initial review of firms' implementation plans. That review was focused on larger, actively supervised firms, and noted that while some firms are in a good position, others are further behind, and there's a risk they might struggle to comply with the expectations once the rules are implemented. So to give an overview of what you might do, the first key step is a gap analysis. Firms aren't starting from scratch. There are, rules and standards already in place, and the consumer duty might not touch every aspect of your business. The FCA in the review they released today stressed that effective prioritization is is key at this point, and that looking at where you're likely to be furthest away from compliance and what you can do in the time available is going to put people in the best position to sort of do everything they can by July. The next step we would flag for early work is around documentation. Consumer understanding, as I mentioned, is one of the 4 outcomes, and our expectation is that, you know, reviewing existing agreements, disclosures, and communications, and pushing through amendments on those documents will take some time, particularly if you're building in consumer notice periods. There's also a need for testing of your communications for customers, which also needs to be built into those timelines. So that process really should start now. Another key area for compliance and product teams will be building the framework around, you know, how do you assess new product launches and how do you, move through that testing process. The FCA has noted that many plans they've seen are quite high level in nature, and that over the next 6 months, firms should really be engaging with the substantive requirements of the directive and digging into what they need to do to build out and implement their frameworks. Responsibilities and code of conduct requirements also need to be embedded for both senior management and staff more broadly. Boards, as I mentioned, have increased obligations, and there's also new conduct rules that staff need to be aware of to make sure they can perform their roles. You know, the FCA again has stressed that governance and oversight is key to implementation plans, and that management needs to be scrutinising and challenging progress over the next 6 months. Finally, ongoing compliance and monitoring will also need to be embedded. And appropriate reporting to board level is going to be really important. As part of the consumer duty, firms need to be able to evidence and assess and react to any findings of where things might not be going so well. And, you know, outlining those data strategies now so that you're collecting the right information and making sure that's escalated in the right ways is going to be very important to how you comply once these rules come into effect. So that's really just a bit of an overview, and it's important to engage now with these new requirements and make sure that there's a clear roadmap over the next few months. I'd recommend looking at the FCA's review that was published this morning. There's a lot of good practices and areas for improvement that they've identified that will help people make sure they're on track with their own plans. So if we move on then to what else is on the agenda, although that might already feel like quite a lot, financial promotion and disclosures to retail customers continue to be a hot topic for the FCA. And I think that really goes hand in hand with their consumer focus. And there's a few expected developments in this space. For high risk investments, the FCA issued final rules on strengthening financial promotions in August. The majority of those new rules apply from 1st of February, so next week, although some changes on risk warnings came into effect from the 1st of December. The background to these rules is that whilst the FCA accepts that, you know, high risk investments do have a place in a well-functioning consumer market, consumer research shows that too many consumers invest in high risk products that aren't aligned with their risk tolerances and don't meet their needs. The changes include, you know, a reclassification of products, so taking the existing rules and sort of harmonizing how those fit. So moving into categories of readily realizable securities, so listed shares that can be mass marketed, restricted mass market investments like unlisted shares and bonds where marketing is permitted but subject to restriction, and then non-mass market investments such as pooled investments in unauthorized funds for which mass marketing will not be allowed. As well as these classification changes, the new rules include enhanced risk warnings and new requirements in the customer journey, which are intended to really increase more friction and allow customers to think about what actions they're taking, such as calling off periods or assessments of suitability. On the theme of financial promotions, we've already heard from Kim about the proposals for a new gateway, so for financial promotion approvals in the Financial Services and Markets Bill. And the FCA launched their consultation in December on how they would operationalise that new gateway once it comes into effect. Those proposals provide an overview of how the FCA will assess firm applications, proposals for changes to how financial ombudsman protection might apply to, you know, breaches in the financial promotion space, and introduction of new reporting and notification requirements. That consultation closes on the 7th of February, and final rules are expected in the first half of this year, although subject to the legislation being in place. We'll pick up on this again a bit later, but it's also worth noting in this context, you know, that crypto assets being moved in scope of the financial promotion rules are all part of this same move. And actually the consultations I've discussed also talk about how they would approach crypto assets once those are in scope of the regime. And then finally, the 1 point flag, which you've already heard about in the scope of PRIPS, but also applies more broadly, for example, to the Payments Accountant Directive. We're seeing that shift away from standardized EU disclosures to more outcomes-based regulation. And, that's something the FCA has long believed is important. And so we'll continue to see that progress over the next year. If we move then to the next slide, finally, and by no means least, we're also expecting changes in the consumer credit and payment space. To briefly discuss some of these, I think, most people are aware that buy now, pay later is something that the government is looking to bring in scope of regulation. We still don't have those draft regulations as of yet, but the Treasury did promise a few weeks ago that they hoped to release a consultation in the coming weeks. So that is something to look out for. The Treasury has also published its long-awaited consultation on amendments to the Consumer Credit Act from 1974. Those responses are due in March. That's really aimed at aligning the Consumer Credit Act more appropriately with the current credit market and other FCA policy, including supporting innovation and addressing digital models, which obviously just weren't contemplated in 1974. Similarly, in the EU, they're also looking at modernising consumer credit with a new Consumer Credit Directive, although important to note that does not create a single market for credit in the EU. People may be not unhappy to hear, but it is. Payments reform is back on the agenda. The EU is carrying out its PSD2 review with a look to PSD3, which we think, although delayed, may be expected in 2023. The UK is also taking its opportunity to review that regime. We had a call for evidence earlier this month. The paper touches on a number of consumer protection issues, such as changes to insolvency protections, including possible changes to safeguarding rules, updates to contractual requirements, and looking again at fraud protection, including strong customer authentication, which is also a topic in the EU's proposals. There are also more structural changes being proposed, which tie into the sort of future regulatory framework that Kim mentioned earlier, and that call for evidence closes on the 7th of April. I think, key thing to note is that given these two reviews are ongoing simultaneously, we can really potentially see the possibility of increased divergence between the two regimes as we sort of move further away from that Brexit transitional period. And then finally, the government and the payment systems regulator continue to be committed to tackling fraud, and authorised push payments are still something that's in the spotlight. As we move into 2023, the payment systems regulator has been consulting on further measures relating to reporting of that fraud, and that's something we can expect to hear more about in the rest of this year. I'm now going to hand over to Mark to talk about some fintech and crypto developments.
Thank you very much, Sarah. So in the time that's left before we move to questions, I'm going to spend a few minutes just talking through some fintech and crypto related developments. So starting with crypto, fair to say that after a few years of quite exponential growth really in this space, the last few months of 2022 were really characterized by a sort of equally adverse and opposite regulatory reaction. We've seen, obviously, has been well trailed the FTX insolvency, but also a number of other firms in the crypto space that have entered into distress situations with really some indication there around contagion going on. I think it's no secret that the crypto space to date has been subject to relatively low levels of regulation when compared with other areas of financial services. So, there's been a distinct lack really of international consensus around how to regulate these activities. We're starting to see that emerge a bit more now, but not really done hitherto. And so whilst you've seen some jurisdictions being early movers in establishing bespoke tailored regimes for crypto regulation, the really major jurisdictions like the UK, US and EU have tended to adopt more of a wait and see approach, and what intervention there has been somewhat more limited and targeted. So the result really has been a kind of balkanization effect where different countries have gone off in different directions and done their own thing. And within our region, really the only harmonized rules we've got are around AML registration and compliance. Areas like investor protection, prudential supervision, oversight around how custody assets are held and so on have really remained outside the scope of any harmonized regulation. I guess it's probably too early to speculate really as to whether those sort of regulatory underlap, if you like, has caused or contributed to these collapses. But I think it's fair to say that regulators did not have the tools available to them they would have had if they were dealing with a more traditional market, and that probably has not helped. So the sorts of controls we've seen in securities markets, such as restrictions on exchanges trading against their own capital, requirements around collateral of trades, reporting requirements that give authorities visibility on interconnectedness, all that stuff has been missing, and really reminds many people, I think, of some of the issues we saw in the last financial crisis around the Lehman insolvency, albeit in a smaller and more niche way. But there's many themes that have sort of repeated themselves in this situation, and we all know what happened sort of after that 2008 happened. There was a very big wave of rulemaking that happened, with Dodd-Frank Act in the US and a number of reforms within Europe. So we can sort of see the same type of thing starting to happen here. We've seen the ECB come out with statements around concern around contagion risk in this market. We've seen the FSB coming out with a consultation last autumn suggesting that there should be a greater degree of alignment with traditional financial services regulation in this space. We've also seen, closer to home, we've seen the FCA starting to take a close interest on a supervisory level around what exposures people have, and inquiring as to, what due diligence has been done on some of these now insolvent counterparties. So what are some of the key initiatives that are ongoing? We've put a number of them on the slide. I think it's fair to say the progress here in the UK has been slowed down by the political turbulence last year and the change of government. So many of the plans that were announced in FinTech Week last April around a new Royal Mint issued NFT, for example, haven't yet materialised. The government promised a crypto asset engagement group to be formed, but that's been downgraded really to a more informal series of roundtables. So things are moving quite slowly. There have been some concrete efforts to regulate stablecoins and bring crypto assets into the perimeter for promotion purposes, as Sarah was saying. That those have run into a bit of a wall in Parliament, but we're expecting that with the passage of the bill around Easter time, that those at least there should be progress made on those areas. But I think it's fair to say that notwithstanding that, we're not going to see this regulatory situation be completed this year. It's clear that the government is looking at what's been going on in the last few months and seeing what else they might do to bring in new rules. So potentially we might see a wider consultation around regulation of crypto assets, potentially bringing things like DeFi in scope and so forth. So there's quite a lot that's still going to happen. The key dates that we do know about for 2023, as well as the UK stuff. So April 2023 is an important date with the European Parliament plenary vote on MiCAR. So I'll talk a bit more about that in a second, but this is a very wide-ranging EU level regulation that's going to really bring in a very comprehensive framework for regulation of crypto token issuances and crypto service provision around Europe. And I think everyone expects this to act as something of a blueprint globally for other jurisdictions. I'll come back to talk a bit more about the substance, as I say, in a moment, but I would just note for current purposes also that very much in keeping with the theme of authorities playing catch up with events, they're already talking about a possible MiCAR 2. So this one hasn't even got the ink dry on it yet, but they're already thinking about a future one to take account of some of the more recent insolvencies and other events we've seen. The EU and UK have also published legislation to implement FATF's travel rule for virtual asset firms. So that these are rules that require financial institutions to send and record information on the originator and beneficiary of a wire transfer. So the UK version of that is going to come into effect in September, and the EU version will be considered alongside the MiCAR package in April. So if we may just move on to the next slide. Yes. So I said I'd give a bit more detail on MiCAR. So it's a very long regulation. It's very wide ranging. There's an awful lot of stuff in it. So it's quite difficult to break it down into simple blocks, but I've tried to do that on this slide. So you're going to see, first of all, a licensing framework for a crypto asset service provider, or called a CASP for short. So they'll need to be licensed to operate in where they do so in the EU in the EU, and they'll be licensed by a national competent authority, but there'll be a degree of oversight of the largest firms that is done by ESMA, which is also going to be tasked with drafting standards for those firms around things like information disclosure and relevantly to the ESG discussion, environmental impact. The activities that require authorization draw their inspiration partly from the MiFID framework, so things like operating a trading platform, providing exchange services, executing orders for clients, advising or managing portfolios of crypto assets, custody, and so on. There'll be a 3-month period for national authorities to issue these authorizations. And it's worth noting that certain other existing regulated firms like banks, payment institutions, and investment firms will also be able to provide crypto services without necessarily opening separate entities, and in some cases under their existing authorizations. Issuance of a crypto asset won't generally trigger authorization, but there are rules around what needs to go in a white paper. There's an exception to that for that principle for e-money tokens and asset reference tokens, which issuers of which will need to have authorization, and there's also separate white paper requirements for those. The European Commission is going to be given power to designate certain tokens as significant, and the EBA will also be given powers to support that process. And there'll be enhanced requirements that go on to those sorts of tokens, including things like how you manage a reserve of assets, remuneration rules, interoperability and liquidity management rules, as well as orderly wind down plans. And importantly, given some of the concerns there's been around stablecoins to date, the reserves backing these tokens will need to be independently audited on a 6-monthly basis. There'll also be a market abuse regime, so there'll be a new definition of inside information for crypto assets and requirements to detect and deter market abuse. Significant CASPs will be required to disclose their energy consumption, and there's going to be some further technical standards from ESMA around how firms need to report those matters. It's worth noting that certain asset classes like NFTs are going to be outside scope, unless sort of specific features are present in relation to them. There's been one controversial area around stablecoin transaction limits in particular, where MiCAR has set down a number of transaction limits for certain types of asset reference tokens and e-money tokens, meaning that this will inhibit effectively non-euro denominated tokens from being issued in the EU where they breach those thresholds. So if I just move back to the next slide, on the next slide, please. So for the UK approach, so we've covered a number of these things already, so I don't want to go into this in detail. What I would just like to say is that the current proposal around regulated activities, which is the one which translates most neatly to MiCAR, there on the left of the slide, the stablecoin regime, that is much more limited than MiCAR. So essentially, this will require certain service providers providing similar activities such as issuing tokens, providing custody, executing transactions, etc., to become FCA authorized, but it would only apply to stable coins. So that the exact definition of that is still to be finalized, but a more limited set of tokens in scope. As we said a couple of minutes ago, though, we do expect the government to come forward shortly with revised proposals. Andrew Griffith, who's been name checked a few times today, he has said that he believes MiCAR is a good package, but could potentially go further, and there may be areas where the UK wants to expand on MiCAR. DeFi is an obvious one, so we await that. But I think on that, some indication of that regulatory competitiveness starting to emerge also between the UK and the EU. So if we can move away from crypto just for the last couple of minutes, just to talk briefly about payments. So there's 2 consultations ongoing in relation to payments, and Sarah's mentioned one of them. This on this slide is the other one. So this is the expansion of the systemic payments perimeter. So by way of background, the Banking Act 2009 contains a framework for the systemic oversight by the Bank of England of systemic payment systems. There's not very many firms that have been designated under that framework, because there's a few firms and then a couple of critical service providers to those firms. What this proposal will do is to update that legislation to essentially recognise that, in the government's view, some other providers in the payment space could be systemic. So not only a payment system, but other providers. So it's not entirely clear who this is targeted at, but because of the way the definitions are cast, there's quite a broad range of firms that could come within scope. So potentially large acquirers, banking as a service companies, digital platforms. Again, it'll be subject to an individual designation by the Bank of England. So it won't be automatically bringing people in scope, but a potential scope creep there of this regulatory regime. In this same paper, they also dealt with the concept of expanding the SMCR, and that's not only in relation to the Bank of England designated firms, but also they float the possibility in the Treasury paper that would apply to all payment and e-money firms potentially under the FCA regime. So that's something which, as we've said here on the slide, it seems they are minded to do. Unclear where it will land, but clearly there's a direction of travel that's looking at potential SMCR expansion to PIs and EMIs. If we just move on, so I think Sarah's largely covered this already, but just to remind that this review of the PSRs is currently going on and is open till April. Sarah called out a number of the areas that addresses around things like SCA, settlement times. I think one area to really look at will be safeguarding, because at the moment there's very few prescriptive rules around this. It seems as though the FCA is going to be given a mandate of drafting a more specific rule book akin to the CAS rules for investment firms to prescribe safeguarding rules. So quite an important and interesting one that for EMIs and PIs. If we can just move on to this slide. So the other sort of fintech related angle really is around the extension of regulation to currently unregulated tech companies. So both the UK and the EU have got their own parallel initiatives on this. So the EU's got the Digital Operational Resilience Act, bit of a mouthful, DORA, which is creating a new supervisory framework for firms providing what are classed as ICT services. And that will bring a number of those designated as critical within direct supervision of whichever is the relevant European supervisory authority, depending on their sector. And in addition to that regime, it also upgrades the current outsourcing rules. So there's going to be a bunch of new rules that apply to contracts entered into with third-party service providers in this space. And the timeline for that is from January 2025. And then the UK regime is somewhat similar in terms of designation. The main difference is that it doesn't, unlike DORA, it doesn't deal with contractual requirements. So that's something that at least currently doesn't appear to be being amended from a UK perspective, but there will be this new designation regime. And we've mentioned briefly the systemic payments perimeter that has an impact also on service providers. So if we can just move to the next slide. So just a couple of other things to mention. We're expecting some developments on DLT sandboxes this year. The UK's FMI sandbox for market infrastructures is expected to go live by the end of this year. The EU's got its own parallel regime. We also may get some movement around open finance. So the Commission's proposing for an open finance framework, which we expect in the spring. The FCA is also carrying out some work in this area. And finally, the regulators, as I mentioned at the outset, are looking more actively at artificial intelligence. There's a current joint discussion paper out on that at the moment. So with that, we've got, I think, just a couple of minutes for questions. So if I can move into those. So we've had a number of questions. We won't be able to get to all of them, but we'll just pick a couple out. First of these is, I think, for you, Philip. So the question is, do we think the FCA has given up on pursuing insider dealing cases given the noticeable lack of enforcement outcomes over the past 5 years? Philip, have they given up?
Thanks, Mark. Well, if you'd asked me a couple of hours ago, I would have given you probably a different answer, because as I mentioned very briefly on the section that I was running through, that they announced this morning that they've brought criminal proceedings against 5 individuals on insider dealing charges for effectively using CSDs across, it looks like, about 49 companies, so quite a substantive insider dealing ring. But more generally, to your question, these are hugely resource intensive investigations for the FCA. It takes years of work for them to sort of get them in a position that they're able to progress, and invariably, quite often, they'll lead to appeals, so they'll run on for several years. So you could see why there's the temptation to divert resources elsewhere. And I think, given that we haven't sort of seen much activity in this space really throughout much of Mark Stewart's tenure, then you could be inclined to think that that's maybe what they've done. So very interesting sort of development this morning that we've just seen.
Great, thank you very much for that. Maybe we've got time for one more question. Maybe Sarah, if I can come to you because it relates to the consumer duty. You mentioned briefly in your segment the testing requirements for the consumer duty. Is there any more colour we can give to the audience on what they should specifically be thinking about in relation to testing?
Yeah, absolutely. Look, the idea is that communications need to be understandable for intended recipients in your target market. And I think, the problem the FCA has identified is that legal teams, compliance teams, marketing teams who reviewed those suffer from, potential risk of groupthink. They understand it because they wrote it and they reviewed it, but do the consumers understand it? And, these requirements, as ever, are intended to be proportional. You need to think about, is this a type of communication that really consumers is so key that they need to understand? So it's not testing everything. But what the FCA, I think, have interestingly said is, you should ask yourself, are you applying the same standards to testing, understanding, as you do to testing whether it's going to be successful from a sales and revenue perspective? So, what firms need to do is think about what is the purpose of a communication, what is its context, and what's the risk of harm if it's misunderstood. And so if there is a sort of reasonable risk of harm, then that's when testing and looking to make sure people are understanding it becomes more important.
Great, thank you very much. So as I say, we haven't managed to get to everyone's questions, but if we didn't, we can engage with you bilaterally about the outstanding questions. So I think all that remains is to say, thank you very much for taking the time to listen to our webinar and for your questions. You should feel free to get in touch with any of us around any follow-up questions. So we'd love to speak to you further if you'd like to do that. As I mentioned at the beginning, today's session has been recorded and will be sent out to you shortly if you missed anything and would like to catch up. Thank you once again for listening today.